Richard Mdluli is asking Judge Bert Bam to recuse himself from the trial in the Pretoria High Court, saying the judge is biased against him. Mdluli, together with Heine, Barnard and Solomon Lazarus, are accused of looting the Crime Intelligence's secret slush fund. They're charged with fraud, corruption and theft. Mdluli's advocate, Ike Motloung, says Bam must recuse himself, as he has shown during previous court proceedings that he's not interested in Mdluli's freedom, that he allowed the media to record the proceedings without input from the parties, and that Bam issued a baseless warrant of arrest for Mdluli earlier this year. Motloung told the court his case needs an open-minded judge without preconceived ideas. He says they fear Bam will not be impartial. And of course, the application does continue. For more on this story, we cross now to our reporter, Patricia Visagie, who's been covering the story. Thanks very much, Patricia, for joining us. Just give us a summation of what came out of the court today.
Well, thank you so much and good afternoon to our viewers. Certainly both those applications dismissed by Judge Bam here. And just to delve into some of the other elements that transpired in this case, I'm now joined by Mr. Mdluli's legal representative, and this is Advocate Ike Motloung. Just in short, one of the other applications that you did to bring forward deals with the funding for this particular case. Just elaborate that to our viewers.
Yeah. Okay, but let me first make a correction. You say the applications have been dismissed. There was only one application before this judge. It was the one for recusal. The other one is the one that the state intended to bring in terms of Section 342 capital A, which the state ultimately abandoned. Okay? So there's only one application which the judge has dismissed, and the judge has not given his reasons for doing so. He said he will give his full reasons within 2 weeks. Did he say something like that? I think so. So we are still to find out what are his reasons. But I can assure you, I'm more than confident that I'm standing on sound legal ground. I've even referred the judge to the Supreme Court of Appeal that this blanket approach of his to say I've previously made orders regarding media coverage, etc. Now, that, like I'm saying, we'll hear once the full reasons are out.
So now, the issue dealing with the media's presence in this case that you're saying is not fully ventilated yet. We're still going to deal with that.
Yeah, because he has never dealt with it. He has said it in this open court that he said that if we bring it, it will be a waste of time because he has previously made an order, which is a standing order. And I'm saying in terms of the law, that's fundamentally wrong. It must be a case-by-case approach. And the Supreme Court of Appeal has said it in more than obvious terms to say that a blanket approach, either by the state to say no media coverage or a blanket approach to say that it must be there even if a witness or an accused expresses reservations, is wrong.
Why do you feel so strongly that perhaps the media's presence in this case you feel should not be allowed? Why are you against the media being here?
No, that was never our request. Me and my client are for media coverage. Then you have seriously misunderstood us. It's not about the media presence. It's about the television, TV coverage. Okay? And the judge himself says his standing order is the one that says, no, look, when witnesses are testifying, they mustn't be flighted. For what base, or for what good reason? So we don't have a problem with it. But I can tell you, the day we make an application regarding the restrictions that we ask, we're only asking for restrictions on media coverage. For example, the judge, just because we raised the issue, the judge finally had to say something like, no, the media can't roam around loosely here in court. Things that he never said or even thought about until I raised the issue. All we're saying is media coverage is proper, is right, we support it, but there must be restrictions. The kind of restrictions that we wanted him to place, he was not even prepared to listen to.
What are those restrictions?
No, those restrictions will only appear for the first time in the application. Why should I ventilate them in public?
But just for our viewers to understand, remember this is a matter of high public interest.
Yeah, but you know that high public interest, it forgets some of the things. You know that my client was the head of crime intelligence in this country. Do you know that my client has had operations in this country and internationally? And do you know that certain people who have previously conducted covert operations, they need to have their identities and other later things kept under wraps. So, but I'm not going to give you the full story. I just need a judge who's prepared to listen. The Supreme Court of Appeal says the judge must listen and the judge must do a balancing act about the freedom of the press and the risks and the prejudice to the accused, if any. He was not even prepared to listen.
I could hear that there was a very heated exchange between the two of you. And of course, you keep on saying that you feel that your client has been treated unfairly since the start of this case.
Because everybody seems to have come to a conclusion. Some judges seem to have also come to a conclusion that Mdluli is fair game. You can do anything. He's not far from Kweban in certain respects, where you get an impression that if it's against this one, you will get an order. That's why those prosecutors approached the matter in the manner they did. And the worst thing, you know, which I didn't raise, you know, when you start having the prosecutors being all white and the judges white, and you start thinking about, you know, some of the things of the past.
We're now taking this in a racial direction. Is that not jumping the gun a little bit?
No, race is a factor in this country. I've not raised it in this court, but I'm saying it may be a factor. Because you remember I asked the judge as to why is it that when Arno Rousseau says something and I say something which contradicts it, why is it that he decides to take that which Arno has said without even investigating? I don't know the reason. Who knows? What if it's color? Because it's been said with a white mouth, then it goes. There was a duty upon the court to investigate. Why did the court has not even told me up to now, why did he issue a warrant based only on the say-so of Arno, which is hearsay by the way. So race is a fact, and I'm not one of the people in this country to shy away from race, okay? I can tell you, my history cannot allow me, and I don't fear it. That's why I'm saying it here now.
Just a personal touch. You are at liberty to share this with our viewers.
Yeah.
How is your client doing emotionally with all of this happening?
I think I'm his fortress, whatever. I'm his anchor. He knows with me behind him. This battle, one day, we will laugh longer and best.
Just in closing, before we go to the NPA, there's also the matter of funding. Just give us a quick summary on that.
No, on funding, our request is simple. You know this gentleman called Begicele? You know that there was an inquiry into his fitness to hold office previously. You remember that? And then that thing was being chaired by the late Judge Ike Motloung, okay? And he was being represented there by a senior counsel. And the police force, SAP, has never had a problem funding that case, or the state never had a problem funding that case. There are many other similar cases. But why is my client not going to be paid for? We are not saying we want somebody different. I can assure you I'll be part of that team, but it may well be that I may rope in another mind. You remember that two minds are always better than one? And look, the two of them are sitting together there. Why? Because they believe in it, that two minds are better than one. So that equality of arms, we need it. Okay?
You feel that you feel that the taxpayers have to, of course, fork their money?
No, this guy was serving the nation as the head of crime intelligence, and he has not been found guilty. Why can't the state pay? And if he's found guilty, then we know that he must refund the money.
Is it because he does not have funds anymore?
No, I don't know. I'm not going to even go into that space. But I don't think anybody in this country, no one in this country, can foot the kind of litigation that my client has been subjected to out of his own pocket. Even the judges themselves who are making this pronouncement, they can't fund it. If they were to, any of them was to be arrested, they wouldn't be able to fund it.
Do you feel that his human rights and his human dignity has been spat upon?
A lot. It has been spat. But remember that matter where he's in custody, the one of the 5-year prison sentence. Remember that we're appealing that. So the last word has not yet been spoken on that matter. And in this one, we have hardly started in this one.
I think I'll have to leave it there. Thank you so much. There, of course, the legal representative of Mr. Richard Mdluli, that is Mr. Ike Motloung. So let's turn to the NPA to just, of course, give us their side of the story here. Right now, speaking to the spokesperson for the NPA's investigative directorate, and this is Cindy Swatwala. Thank you so much for joining us. The state's application, give us, of course, just a summary into that main application that they brought to court today. Of course, the basis of it, as the NPA did indicate earlier, is because they're trying to stop Mr. Mdluli from having any further delays in this matter. Just expand that for us.
So we've been very clear that we require that the presiding officer decide in the 342A of the Criminal Procedures Act. This is us bringing the application, requesting that that they finalize any things that they want to tie up before pre-trial in June. So we initially came to court wanting to bring that application so that can be decided on. When we got to court, it was ventilated somewhat, but we didn't get into the merits of that application. The judge, as well as the defense and ourselves, conceded or agreed that it's best that he finalize all the applications that he'd like to do within 30 days. This is him finding the state to fund his legal representation. Because we were saying that the longer that this drags out, it might appear that in October, when trial is supposed to start, that he still doesn't have any legal funding. That will hamper our case, because we want this case that's been on the court roll, in and out of the court roll for the past 10 years, to be finalized. I must also just remind you that this case has had many delays in terms of the declassification of documents. That's the first delay. That's the first stumbling block that we encountered as the investigating directorate. We then lobbied the NPA, NDPP, and the head of the police to declassify the documents in this particular case, and that has thus successfully been done. That's just the type of delays that we're trying to ensure that they do not take place, that this case will proceed. So what we're saying today is that we want the defense to finalize the application for any funding that they'd require within 30 days, so that when pre-trial happens in June, he can join his other two accused, and then the matter can proceed and trial can start in October. That's all we're doing. The recusal of the judge, an application brought by the defense, was denied. You heard that, and reasons were given. And the judge, just to add, did say that it's bordering on malfeasance.
All right. I see that we are, of course, almost about to resume again. Just in short, what can we expect now?
We're not quite sure. So the judge literally just called all the parties back to court. We're yet to find out what that is about.
Just in closing, the issue around the media, that of course being raised very strongly this morning. You can now see that it's even culminating in some of race-related allegations that are now made by the legal representative of Mr. Mdluli. That issue about the cameras trampling on his dignity and of course resulting, as he says, in an unfair legal process. The NPA's response on this?
First and foremost, I speak for the investigating directorate under the NPA. It's the judge's prerogative to decide whether or not to allow the media. So he's taken that decision. I'm not one to criticize it or to question the reasoning behind it.
All right. Thank you so much. There you have it from, of course, Cindy Swatwala. She is the spokesperson for the investigative directorate under the NPA here in court. You can see there Mr. Richard Mdluli sitting quite calmly so. He's a legal representative there standing, and of course the state two lawyers also sitting there as we all wait to hear what exactly is it that the judge has urgently called everybody back for. Originally, we were done with this case, but it seems like there is an outstanding matter that has forced the case to speedily resume. On that note, I think let's toss it back to studio for now.